Did you know there are ways to structure yourself and your real estate to avoid future problems for yourself and your loved ones? Well, today we're going to learn about trust. Hi, it's Orlando from Keller Williams Realty, and I have Jeff Busch from the law office of Jeff Busch in Elk Grove, California. How are you doing, Jeff?
I'm doing well. Good morning. Thank you.
Well, I do appreciate you helping us with this topic. I know that I have a lot of clients that had questions about how to structure their properties as far as the entity and the vesting of their property. So, what I wanted to do is just introduce what a trust can do for them. In general, why should people have a trust?
Well, first of all, not everyone should, but I would say probably 90 to 95% of individuals should. And that is in order to avoid court. That's what I tell my clients when anyone asks or when they're not sure why, it's to avoid court. If for the most part, we're talking about real estate because individuals can name beneficiaries on their bank accounts and on their life insurance and their 401ks and 403bs and IRAs. And you don't need a trust for that. They don't need a will for that. It's the home. And even though there's kind of a quirky deed where you can name a beneficiary, I'm not a fan of it. In my opinion, the best, smartest, safest way to transfer property upon your death is through a revocable trust.
Okay.
And
Now,
that's to avoid court.
Okay. Now they're probably wondering, how could this end up in court? If someone passes away, they have a property under their name. Why would it end up in court? Is what I probably
Because
hear.
it's actually a benefit. It's critical for the successful ownership of real estate to have clear title. And so one of the purposes of probate, and that's where it can be a good thing, is if there's a question, the probate court will determine who holds clear title to a piece of real property. So the title company will feel comfortable in in transferring that and guaranteeing that it does have a clear title. If an individual or couple has taken time to set up a revocable trust, then they have clarified at that time ownership of the property, so that the court says if you'll set up a trust and you'll do it right, then we will not make your children or who you're giving it to go through court, and that we'll
Okay,
let you avoid probate.
got you. So for those of you that don't know what probate is, it's basically when there is not a clear title or a defined person to receive the property, it goes into the court and the court has to hold it until they declare.
Well,
Uh,
they have to confirm who's entitled to ownership, and it's not just real estate, but that's typically what it does belong to. So probate is a court process whereby the court makes a determination as to who should be in charge of the estate, the personal representative, and their title is typically executor or administrator. And then it's also a purpose is to give notice to any potential creditors out there. A probate typically in California is a 12 to 24-month process. And part of it involves publishing a notice in the newspaper. And the purpose of that notice is to give creditors, to put them on notice so that they can step forward and say, this person owed us money. And then they can, if there is property left, and there's gonna be, or else people wouldn't, you don't do a probate if there's nothing there. So it gives the creditors a chance to step forward and say, we are owed money, we would like to be paid back.
I see. Okay. Now, I'm hearing that probate can also cost a lot of money for the recipient of the property as well.
Probate is expensive. It's not as expensive as some people think, but it's the costs of probate are determined by statute.
Mhm.
And what's interesting is the federal government, the Internal Revenue Service, when they're determining estate taxes, they base it off the net value of an estate. The state of California, the probate court, they base it on the gross value of an estate. So if someone died in San Francisco with $1 million home and there was $1 million mortgage on that property, there's zero equity, but the probate code, they look and see a $1 million asset. So under current law, it's 4% of the first 100,000, and then 3% of the second 100,000, and then 2% of the next 800,000 up to $1 million. So in our example of a $1 million piece of real property, it would be the attorney fees would be 4, 7, 9, 11, 13, 15, 17, 19, 21, would be $23,000
Mhm.
for the attorney fees, and then the court costs are probably going to be about $3,000. And
Wow.
then the personal representative is entitled to compensation in an equal amount. So on a $1 million home, if the executor or the administrator wanted to collect their fee, then the beneficiary, which it's typically a child, doesn't have to be, the beneficiary, they're going to have to come up with potentially over approximately
Wow.
$50,000.
Right.
And that's why, unfortunately, a lot of children who would otherwise love to keep the family home, they can't. They have to
Right.
sell it in order to pay the attorney fees.
And that could have all been avoided if they had set up a revocable trust.
All been avoided with a basic revocable trust. That's correct.
Okay. So let's define, what does a revocable trust entail? What does it do for you?
Well, if it's done correctly, it will allow the children to receive the property without the court's involvement. So when a trust is set up correctly, it's a series of documents. Actually, people refer to as, I have a trust, but it actually, for a single person, it would consist of 6 documents, and for a married couple, it's 9. But that would include a trust declaration, a certification or abstract of trust. There's still a will. It's a pour-over will, and a durable power of attorney, and a healthcare directive,
Right.
and all of those documents, and they each have a purpose.
Right.
But
Okay.
the trust, the primary document, but it's only part of it. But the primary document, the trust, is basically it's a set of instructions to who is going to be managing the property as to what they're supposed to do with the property while the creators of the trust are alive, and once they've passed away, how it's to be distributed.
Okay. And I could see where this tool can avoid conflicts between family members. I'm sure
It
you've seen that.
actually does, in my experience. When a matter goes to probate, when it goes to court, the number and frequency of conflicts between family members, it skyrockets.
Right.
It becomes much easier for one of the children or one of the relatives to make a scene, sometimes just to be a punk.
Right.
But it gives them the opportunity. They can go into court and they can delay it, and they can do all sorts of things even without hiring a lawyer. If someone wants to challenge a trust, it's a lot more involved and it's a lot more expensive, and there are not court hearings that are automatically scheduled. So I'm not going to say that you can't have a child that can still be a punk, but it's much more difficult for them to make waves.
I see. I see. And if you have somebody like Jeff that's able to structure this trust for you, he's right here in Elk Grove. So, make sure you guys contact him. If you guys don't have a trust already, be sure to contact him, get some advice on this. This is it can possibly save you tons of money. Um, I actually had this situation with the client, and I'm not going to say any names. However, they've inherited millions of dollars of property. Now, of course, everyone's tax situation is different, but because they inherited it under a trust, once their parents passed away, they were able to get a tax step up basis, meaning they were able to avoid paying capital gains on properties that they inherited, which could be millions of dollars since they inherited more than one Bay Area property. So with this trust, what doesn't it do?
Okay, what a trust does is the primary benefit is it avoids court, it avoids probate court. And we yet generally people talk in terms of when someone dies, but sometimes an individual become incapacitated before they die. And with a married couple, even more so with someone who's not married, there's actually, I think, a greater need for someone who's not married to have a trust than someone who is, because there are some things that a spouse can do for the other spouse. But um, if should someone become, let's suppose someone became one spouse became incapacitated, and maybe they have a 2-story home, and so the healthy spouse says, well, I want to have Orlando sell my house, and help me get a 1-story house. Well, they can't sell it if the husband and wife both have their name on the title. Then the healthy spouse can't sell it because
Right.
the incapacitated spouse is not able to sign the deed. They're not able to
Yeah.
sign the listing agreement, so they're stuck in the water. So then they're
Right.
forced to either not do anything, or the healthy spouse has to go to court and ask the court for permission to make decisions for their spouse, ask the court for permission to sell the property, and the court would more than likely grant that
Right.
authority, but it's going to take several months and it's going to be expensive. And 2 of the documents that are included in a trust, if it's done correctly, are the durable power of attorney and the healthcare directive. So the husband can say, if I'm incapacitated and I can't make decisions for myself, then I authorize my wife to make the decision. So if the wife feels that it's best for the family to go ahead and sell the house, then they can go ahead and do that, and they do not have to have the permission of the court. So it's basically it's avoiding court,
Right.
and it's clarifying who the owners of the property want to be in charge, so that even though someone may have sour grapes that they were not chosen, it avoids a tremendous amount of conflict. Now, you had mentioned something earlier. A common misconception is that these are asset avoidance devices. They are not. People, for the most part, people worry too much about that sort of thing. But I advise all of my clients to, if they own real estate, to have an umbrella policy, to add an umbrella policy to their homeowner's insurance. It's usually not very much money, $200-300, and it typically increases the coverage and limits up to $1 million. And as I tell my clients, unless they're doing something stupid like texting while they're driving, or consuming alcohol or drugs while they're driving, or racing and that sort of thing, they're not they're not going to be subject. They're not, first of all, they're not likely to cause anything really serious. Accidents do happen, but you're not going to have to worry about the personal. So I tell people, up your car insurance. Don't have minimums. Have at
Yeah.
least like 100,000, 300,000, and have a homeowner's policy on your home. Take a homestead, and the homestead will protect up to about $100,000 in equity on your family home. But again, for most people, I think they worry too much about that personal liability.
Yeah, that's true. Now, as far as having a revocable and irrevocable trust, what are the differences between the two?
There's a big difference between it, and the vast majority of individuals that should have a trust, it should be a revocable trust. And a revocable, I think it should be renamed so it's actually called amendable. So they can make changes as long as they have their mental and physical capacity. I don't recommend irrevocable trust for individuals unless, for example, if the doctor has just diagnosed Alzheimer's or dementia, then they might want to take a hard look at irrevocable. In an irrevocable trust situation, the creator of the trust is turning over management of their property to a third person. So
Right.
I'm sure in a lot of these situations, it's the parent that's turning it over to a child, and there's not a big deal. But the fact of the matter is they are legally surrendering control of their property.
Right.
And one of the questions too is, before even, when someone, unfortunately, and I've heard this actually twice in the last couple of weeks, is I'm shocked at how much bad information there is about who needs a trust and who doesn't. I was
Right.
speaking just last week with an otherwise very intelligent individual, and she has some friends who were lawyers, and her friends were telling her that a will was all she needed and she could do it herself. And I'm like, I don't even know where they come up with this stuff. But here's my little simple rule of thumb. Everyone should have a will and a durable power of attorney and a healthcare directive. Everybody.
Right.
If you don't have anything, if you're over 18, a woman came to see me several years ago. She and her boyfriend it was a 1971 Chevrolet Caprice. And for people who were into show cars, that was pretty popular car for customizing and putting nice wheels on it and custom paint and things. Well, he died, and the title to the car was in his name only, and he didn't even have a will. And so she came to me wondering what she could do, and I told her, I said, you have no legal rights to that car because he didn't have a will, and you're not on the title. So the best you can do is go to his mom and dad and ask them for the car, and hopefully they gave it to her.
Oh boy.
So everyone should have a will, a
Yeah.
durable power of attorney, and a healthcare directive. If an individual owns a home, which means even if they're buying it, even if there's a mortgage, even if they have no equity, even if it's upside down, that hasn't really been an issue for a while of homes being upside down, but it
Right.
was once upon a time, and
Yes.
it may yet again. But if they have their name on title to real estate, or they have assets that exceed $166,250, and that would include life insurance, 401ks, IRAs, investment accounts, stocks, bonds, cars, boats, all that other fun stuff. Or if they have minor children,
Hmm.
just in my opinion, the safe, smart way to approach life is to have a trust.
Okay. Now, is there a particular why is it 166 250. Why?
Yeah,
What?
'cause that's what the law says. Now, if it's real estate, I'm going to say if you own real estate, period.
Yeah.
But if you don't own real estate at all,
Okay.
and all your assets are in bank accounts and life insurance, the state of California, the current law is they say if the amount you own total, well, first of all, let me back out here a little bit. If if you name if my wife is named as beneficiary on my bank accounts, when I
Mhm.
die, that passes to her, and that's not counted toward probate.
Right.
If there's a beneficiary on life insurance, that doesn't count toward probate. So when I use that figure, 166,250, I'm talking about $166,250 that it's just hanging out there. It's
Right.
in the name of the person who died. They did not name a beneficiary. I don't even know. I personally think it should be required that banks should not allow you to set up an account unless you name a beneficiary.
I see.
But that's not the law.
Right.
So assuming that's what the current law is, it was $150,000 for years and years and years. If someone dies, they have no real estate, and they leave $166,250, then there's a very simple form that can be used, a legal document that can be created. The children could take it to the institution and present it, and the money would be released. It would not have to go through court. If it's I had two sisters actually came to see me. Their mom had a trust
Right.
done by a lawyer, but the lawyer left out a very important part of the trust. And this was their mother's. I'm not exaggerating. The amount in the investment account was 150,000 and like $1,
Mm.
and so it was $1 over.
Right.
So we had to do a full blown probate on that investment
I
account.
see.
If it had been
Okay.
if it had been $149,999.99,
Yeah.
then we could have prepared a small estate affidavit, is what it's called, and
Okay.
presented that to the investment company. They would have released the funds, and a probate would not have been required.
Okay. So all in all, the we talked about the benefits of a trust, the do's and don'ts. With your services, if somebody were to inquire about setting up a trust, what are the fees that you guys charge?
What we for an unmarried person, it's typically around $1,000 if they have one home, if they have just the home that they're living in, and that includes the trust, the will, the durable power of attorney, the healthcare directive, the certification of trust, the assignment, the Schedule A and B, and the trust transfer deed, and the recording fee and the notary fee, because most of those documents are notarized.
Right.
If it's a married couple, it's going to be typically a little bit more, maybe $1,250 to $1,500, depending on how much if they have additional pieces of real estate, or if they have any complex distribution. But a lot of the married couples, that's it. It typically falls in the $1,250 to $1,500, and that's compared to, I've been told by my clients that, who met with other attorneys, that they've been quoted anywhere between $2,000 and $4,000
Right. I've
to
seen that
prepare
before
these
too.
documents. And just my feeling is that if it's not a complex trust, it shouldn't cost somebody an arm and a leg. And that's why a lot of people unfortunately don't get this done, is because they get bad information on how expensive they are. And they're
Hmm.
like, well, I don't have $4,000 to have one
Yeah.
of these things done, so they don't get it done.
Right. Now, if they were to inquire about whether they should go and pursue getting a trust, is that something they can talk to you about?
Yeah, and I don't charge anything for someone sitting down with me
Okay.
and asking me questions. And I do like a little estate planning audit and tell them what I think they need
Yeah.
or what they don't need. Correct.
Okay. Well, I do appreciate the information. It was very helpful. I'm sure, my clients are going to find that helpful as well. And guys, keep in mind, having this trust is going to help you. If not now, it's going to help you out in the future and for your loved ones. So, again, Jeff Busch, law office of Jeff Busch. He's right here on Laguna Springs Drive, right next to Five Guys. Actually, close to my office, right across the street as well. So, thank you so much, Jeff. I appreciate it. I'm going to post your information for your contact on this video as well.
Thank you, Orlando. I appreciate it.
All right. Well, have a great day.
You too. Take care.